Hello everyone, and welcome to the Equal Pay Act and You. My name is Blake Bundy, and I am a human resource consultant for Rick and Morty Incorporated. Today, we are going to be talking about the Equal Pay Act, how it was founded, how it is enforced, and what you can do to make sure you stay compliant with it. The Equal Pay Act of 1963, also known as the EPA, was enacted on June 10, 1963. It was enacted by the 88th U.S. Congress and signed into existence by John F. Kennedy. The purpose of the law was to eliminate the pay inequality between men and women. Women at the time were being paid far less than what their male comparators were making. It also gives employees the chance to bring litigation against employers who are discriminating based on sex by bringing able to file charges with either the EEOC or with another court. This ends up being their decision since the law does not have a statute of limitation making it have to go through the EEOC first. There are several laws that help supplement the Equal Pay Act. At the federal level, we have two laws that supplement the Equal Pay Act. First, we have the Fair Labor Standards Act of 1938, which established minimum wage, overtime pay, record keeping, and child labor standards for employees. This was later amended to include the Equal Pay Act in 1963. Another federal law that supports the Equal Pay Act is Title VII of the Civil Rights Act, which prohibits discrimination based on sex, race, color, or national origin and religion. There are several other counterparts to the Equal Pay Act at the state level as well. In fact, 44 states have an actual equal pay law of some sort governing what pay should be and that it should be equal for both sexes. 4 other states, North Carolina, South Carolina, Utah, and Wisconsin, do not have an actual equal pay law, but do have employment discrimination laws that have regulations prohibiting wage discrimination. The only states that do not have any type of state equal pay or discrimination laws that cover equal pay of their own are Alabama and Mississippi. Since your company is based in the state of Michigan, it is beneficial that we go in a little more depth for the laws that the state of Michigan has passed to help support equal pay for both men and women. For the state of Michigan in particular, there are 3 state laws to help prevent discrimination of pay of employees. One of these laws is the Elliott-Larsen Civil Rights Act. This law prohibits all discrimination based on religion, race, sex, color, national origin, age, height, weight, and disabilities. While this law is not directly focused on discrimination based on sex for wages, there are 2 additional laws in Michigan that are focused on doing just that. One of these laws are the Unfair Discrimination, Restraint of Trade, and Trust laws. This law states that any employer in the state of Michigan who employs both males and females should not discriminate in any way the payment between the sexes who are employed in similar roles. Discrimination of any sort on the wages result in the business being charged with a misdemeanor. The other law that is in place to prohibit wage discrimination in the workplace is Workforce Opportunity Wage Act. This law covers almost exactly what the unfair discrimination law covered, except that it goes into effect only for employers who have at least 2 or more employees. Also, unlike the unfair discrimination law, the law does not result in the business being charged a misdemeanor, but instead gives employees the chance for litigation to sue for damages that they feel they need to recover to be made whole. From the supplemental laws, we begin to look at the ways that the law is enforced. The Equal Pay Act is managed and enforced by the EEOC. This acronym stands for the Equal Employment Opportunity Commission and was created by Congress on July 2, 1965. Since its founding, the EEOC has been responsible for enforcing several anti-discrimination laws. These laws include the Title VII Act of the Civil Rights Act of 1964, the Pregnancy Discrimination Act, the Equal Pay Act of 1963, the Age Discrimination in Employment Act of 1967, Title I of the American with Disabilities Act of 1990, Sections 102 and 103 of the Civil Rights Act of 1991, Sections 501 and 505 of the Rehabilitation Act of 1973, and the Genetic Information Non-Discrimination Act of 2008. We're now going to do a hypothetical situation here where we are going to walk through what would happen if a claim was filed to the EEOC against you. The EEOC is contacted when a claim is filed by one of your employees to them. Once the claim has been filed against the organization, the EEOC notifies you within 10 days of receiving the claim and gives you a chance to respond. The claim does not mean that your organization has necessarily committed a pay discrimination, but that the EEOC may choose to investigate whether it has occurred based on the claim and your response. Before the investigation, the EEOC gives both parties a chance to resolve the situation through mediation or settlement before the investigation occurs. During the investigation, both parties will be required to provide some information. It will begin with your organization possibly submitting a position statement. This gives you a chance to tell your side of the story. From here, you will likely have to respond to a request for information and supply the EEOC investigator with the documentation he requires, including personnel policies and personnel files of certain employees. You may also be required to permit an on-site visit to allow the investigator to see your organization firsthand and could potentially substitute this visit for an RFI. You may also need to provide the contact information for or have employees available as witnesses for the investigator to interview. During these interviews, if the person being interviewed is in a management position, they can have a member of your organization sit there with them while being interviewed, but the EEOC can interview non-management employees without the okay from the organization and with no one else present. The investigator has gathered all the information that he needs. He will conclude the investigation and report his findings to the EEOC. The EEOC will then review the information and determine if discrimination has occurred, with one of three outcomes possibly occurring. Either A, the EEOC will not be able to conclude that discrimination has occurred and will send both parties a notice called a dismissal and notice of rights. This notice informs the charging party that they can pursue further litigation within 90 days, but that the EEOC will not be pressing further litigation themselves. B, the EEOC concludes that discrimination has occurred, and each party is issued a letter of determination stating that there is reason to believe that discrimination occurred and giving both parties a chance to resolve the charge through conciliation. Or C, if conciliation does not work to resolve the charge, then the EEOC has the option to file a lawsuit in federal court for the violations. If the EEOC chooses not to litigate, the charging party will receive a notice of rights to sue and can file a lawsuit themselves in federal court within 90 days. If a charge is filed in federal court, it comes down to the decision of the court to determine that damages must be paid. It is important to note that the EPA does not allow the charging party the chance to recover compensatory or punitive damages, but does allow them to receive back pay, have their pay raise increased to the level of a different sex comparator, have attorney fees paid, and receive liquidated damages equal to the amount of back pay. To help you fully grasp the Equal Pay Act, I believe that giving real-life examples is important for you to understand and be compliant with the equal pay laws. The first case that I want to talk to you about is the EEOC versus Prince George County. In this case, Joanna Smith was hired as an Engineer 3 at a wage amount that the Department of Environment refused to negotiate because they said it accurately reflected Joanna's experience and education. 2 weeks later, they hired a male engineer with comparable education and experience as an Engineer 3 and gave him a higher negotiated salary, even though they were both hired at the same role and doing substantially equal work. On top of that, Prince George County proceeded to pay another male at Engineer 3 a higher salary once he was promoted, and even paid an Engineer 2 who was doing less difficult jobs higher wages than what Smith was receiving. Based on this information, the EEOC pressed charges and the district court judge ruled in favor of the EEOC, stating that the PGC violated the Equal Pay Act of 1963. As part of the resolution for this charge, the DOE had to pay Joanna $139,633 in lost wages and liquidated damages and $5,769 in costs to the EEOC. They also had to raise Smith's salary by $24,723 to make sure her wages match her male comparators. They also needed to hire a consultant to ensure the DOE stays compliant with the EPA in the future. Another example of a violation occurred in higher education when a Denver University professor contacted the EEOC about her unequal pay. In this case, Lucy Marsh was being paid at less than her male counterparts, even though she had worked at the university for 37 years. In fact, all female law professors on average made $20,000 less than the male professors. The EEOC, on her behalf and the behalf of all the female employees at the Denver University, filed a case to help combat this discrimination, with a resolution still not have been made yet. There are hundreds of other violations that have taken place in multiple different industries as well. For example, in the technology field, Qualcomm Telecommunication Equipment Company was accused of not offering 3,300 women equal pay and promotions that they felt they deserved. They stated that they faced large roadblocks to get equal pay and that the promotions were not offered to them. Qualcomm avoided going to court for this, though, by offering to pay $19.5 million in a settlement. In order to stay compliant with these rules inside your organizations, you should make sure that you are treating all employers equally and fairly, and that men and women are being paid the same amount when their jobs are considered substantially equal. This sounds easy, but is often much more difficult than most employers would consider it to be. In order to stay compliant, I would suggest that you require equal skill, effort, responsibility, and job duties with similar conditions for employees doing the same job. This does not mean that the jobs have to be identical in every aspect, but that the work that they are doing is viewed as equal. Please note that the amount of pay that you are giving each employee does not have to be equal for all jobs. However, if a difference in pay between a man and a woman is between two jobs that require the same skills, effort, responsibility, and job duties, then the company is going to have to document why the pay is different. There are a few different ways to do this, such as proving that a seniority system is in place and is actively being followed, or a merit system is in place and is being used. The company can also say that they use a system based on the quality or quantity of production, or that some other factor than sex is the reasoning behind it. This factor, other than sex, works kind of as a catch-all that most courts require, serves a legitimate business purpose. By being able to show and document one of these reasons for the difference in pay, the company gives itself protection against a discrimination claim.